Solomon Owusu oye directions of communications for United Party Alan Kojo Chematin ni emanfo bebreze Alan de oye kofo edoba enti ze mkaya ewo delay show ana delay ebusan ze yesi Alan Kojo Chematin oye odoba ono ananka opese obesi wanan ana delay ebusan ze His Excellency uchire mu say ana o se enye no koreda na empo ebra na me wa ban mu no na Kojo Chematin no wo ye ono na de no wo ye ne business no wo ne na de a wo ran in fact o se wo friend no kwase omaji minister o ka say no oma o say until at a point ya obeye no ambassador to America and I say United States of America and san enumpo Alan Kojo Chematin ne wife emum and etimi convincing no am obefa enti o se obi ka say na ne doba ne Alan Kojo Chematin a na nya no kre na emum no enam ayonkoya ne dwumadie as ambassador to the United States ayonkoya enam ono no Alan Kojo Chematin so Emma His Excellency John Ejekunkofo any US president at the time John Bush ebenyaye o say no ene man be ye so close wa na manfo su say oh even the next primaries no na ono no His Excellency John Ejekunkofo e ba ochifo Alan Kojo Chematin na on joy and opay and of course it's all about the Pandai seat say and your first time wa uti any high airline TV obe subscribe no like no share video na for so nya biahwe Pandai seat no let me give you a little bit of background so na be ya obeti ase na wahu the positions of a lot of politicians on this particular case. Pandai seat 2024 elections ye call ya Africa ba ya enche yi ana Pandai internally Daniel Insala ono at the time no the NDC parliamentary contestant sa ana ye marching in dam currently ono na chese ejaguni chem trese the seat no ye ko ho den na elections ne kwa na wie no December 23rd of 2024 ana Daniel Insala ono na elusi elections no ono na ye the NDC parliamentary candidate ana file a petition e de koma the EC ene the high court Tamale high court say ene ba bi ankoyi so hwade ni din a some procedures EC na follow ana on the pin sheet there are some inconsistencies and irregularities bi ewo mu a e wo se court no ehwe na or rectify na eno ana ode kwada na court busumi etwa mu ya 2025 November bosumi ena court Tamale high court any ruling eba say even though 41 police stations now the entirety of elections and I say the police stations are now Pandai constituency na 152 na 152 ni na court na say wa anole because 41 one the plaintiff no e buy so hemu a na che say otimi extend e de ma the remaining police stations ni na then e buy no e man for be na kire o ma de Dennis Manakarabo aja che na adwen de afa ho say now how can a judge rule on something that it doesn't have a date and has evidence on? And what we say is evidence, not the name of the game. Say eba amamremu dia say mra dia enye evidence ana ye de ya na eno ana ene e man for bebre no ana akire wo mo adwen nti ene ntokwa pipe ana esi ewo parliament on this particular issue. Now on Joy News, Anna Solomon Owusu, sending a medical kind on the directions of communication for United Party, Alan Chematin. And I say, ye castle of execution, and yet when you are the church, they must have Hamza Suhuyini, or one of the leading NDC communications team member, and so will be. And I watch not doing a fact, the Pandai, issue no. And I say court any ruling ba ebi dey say the ruling a Tamale High Court e dey abay na so obi file the stay of execution send here Martin Yindam and then lawyers a file and then the NPP minority caucus a file no a eno no automatically and nullify the ruling High Court e dey aba so long as a High Court NTA now on ruling on a year state of execution any decision odi kan de ba no extended in fact now the NPP representative no na nya adwene na emu a na obusa Hamza Suhini ono so oye lawyer ana obusa nze una aye mranimfo chirichirim se koba se ye file state of execution aya na sign na ho ensensem no etie ene ono so nya adaje ene okotu Ghana amamra no bebre okotu CI 19 ana osa akotu just article 27 of the 1992 constitution ana na o chirechire mu ana ono so chirechire mu say that state of execution enema bi a ye deboa ma se obi di na sem kwadan ne court na se court ndi mu ayeba na one court no enya adwene wo mu aye na wode aba no ho a saa tuzi ema nipa no akwanya ema otimi e dey sign kwadan the court of appeal se na ebe ya obehwe se anka initial response wa ana ruling court ne ba no ye betimi atwentwen so kakra enti se court di ruling ba na se o file the application of state of execution and no nkire say automatically the initial ruling of court no is not binding or say it is still binding until the case in the state of execution is heard and ruling given and the confirm say no be binding there na say the initial ruling court in the by is still binding in fact lawyers for no NT the technicalities in the law na see papa and on this particular issue in fact oka ensem ni bebre mu mientie ni ensem ni bia oka
directing otherwise as far as the High Court decision is concerned there's a final conclusive judgment on the matter that is standing as far as the law is concerned.
So what
and that is the decision of the
educators.
High Court.
What happened to appellate process? With all respect, if I go to a court of first trial,
no, but
a trial court,
I'm
just asking a simple question. No,
you
are a lawyer here.
Come out.
And but if you are patient for me to
but in my simple,
it's a simple question.
It suggests that if the Court of Appeal questions the decisions of a lower court, their decision does
I'm asking a simple question. Why do we have appellate process? You go to court A, and the court says, this is my decision. The court now, the judicial process now gives you a window to appeal against it. And I'm asking simple.
But the CJ has
it's final, and there's an appellate process that has been triggered. When the appellate process is not decided on, does it still mean that that decision holds?
But neither your stay of execution also has been granted,
anyway. Exactly. So, in the wisdom of the law,
there are two things.
In the wisdom of the law, they know that when a lower court gives a decision, it is binding. Until you take steps through an appellate process to set that aside.
Excellent.
It is still binding.
It is still binding.
Yeah.
Excellent.
If you are in court in the form of an appeal, the decision is still binding until such a time that the appellate court determines it. So they have given you tools to ensure that you protect your rights in the interim whilst the appellate decision process goes through. What are the tools? Injunction or stay of execution. But the courts themselves have told you that it does not mean that when you bring these tools before them, it will be granted.
Okay.
And so if you file a stay of execution and the High Court judge rejects your stay of execution, you wouldn't say that the vacancy is invalid because you are appealing, you are the Court of Appeal.
I can't help but come along with this logic.
Are you following the point?
Yeah,
That is a law.
Help but come along with
that is a law. And you see, my brother raises another interesting issue. And he makes the point that when it comes to an appellate process, like the application for an injunction or stay, does not necessarily mean that it is stay. It is true. That is according to, as recent as the Vincent Asafua matter. Yes. I think that the Supreme Court settled the matter and said that when it comes to constitutional bodies, the mere application for a stay of execution or an injunction does not constitute a grant of same, and for which reason one is expected to oblige, especially when it comes to constitutional bodies. And I'll just read it. This is Kulendi saying, JSC, in good conscience and in fidelity to our judicial oath, we cannot endorse a position that could potentially be exploited by deliberate and well-resourced strategy deployed by individuals or entities pursuing parochial private interests to obstruct, delay, and frustrate constitutional oversight and hold the public interest to ransom. End of quote.
You have a higher authority. That
and you see, Anna, but I need to draw a distinction where the confusion is.
Okay.
So this case is conclusive, it's tentative in a way. But even within the legal fraternity, when it comes to stay of executions under CI 19, it is statutory in nature. That one is specific. For example, the 7-day stay, automatic day stay. Then there's also under Article 2, Rule 27(2) or so, that says that the mere application of a stay would operate as a stay until the matter is heard. That is, the application stay is heard. It's also there. Are you getting the distinction, Solo? So now, there's that contention, whether this decision effectively overrides a statutory provision. A statutory provision that has been created and provided for in law. This decision relates to precedents of the same Supreme Court. So we need that.
No, so you get it. We are on the same page.
It's a policy court.
So you see,
it's a policy court.
I have a question for all of you. I have a question for all of you. I have, but I have a question for you so that we'll go to the OSP.
I am trying as much as
Kamal, are you people afraid of the Pandai by rerun or something?
Let me just dispel this information that he seeks. We are not on the same page.
We are.
If there's anything, so I'm trying as much as possible to present the law as it is.
Okay.
And I'm challenging you people.
What do you
go through the legal process.
Let's go on the final round of the Pandai. Let's go to OSP. Anyway. It means a lot to me because of a matter in court. My final question really is, what do you reckon is the reasoning behind the 7 days?
In
before you can declare.
So that if you want,
is it for such issues of stay of execution and appellation?
Exactly.
You see,
exactly.
We first of all, on this matter, the MPP is on record to have filed an application in the Supreme Court as well. Okay.
What are you seeking?
For certiorari.
The MPP or the
candidate? The MPP. Please. You see, we are in the Supreme Court for the Supreme Court to quash the decision of the High Court in the first place. Why? We are making the argument of jurisdiction. What is the jurisdiction? The question you just asked. What is the essence of the 7 days? Time is of essence in law, which my brother knows. We were arguing at the Supreme Court that the time the gazetting of those results took place and the time that the case which is supposed to have been heard by the High Court.
This debate can only be had
with all respect. Yeah. I'm only trying to explain to you why we have series of applications. First, we have one in the Supreme Court, which is the
Do you know why I'm unable to go into the why?
The number of days that you are allowed to have filed, that number of days elapsed, which you didn't pass.
Do you know why I'm unable to go to the why? Come out. Do you know why I'm unable to go to the why?
And two,
the whys presents me to revisit the facts of the matter. What I'm interested in is in the decisions of the court after they have considered all of it.
You asked the question whether the 7 days was actually significant.
And that's what okay.
And I'm only telling you that in law, timing is of essence. That's why I said that we are going back. We are going back to the Supreme Court, even saying that the time that the case was even filed was wrong on the face of it. We have it. Then again, we have again filed at the Court of Appeal, trying to appeal against the decision of the court. So I'm saying, if all these legal processes are there, okay, and my brother sits here and tells me and cites their own laws, which say that there's a statute in place which says that, look, if judicial process is in place, obviously, whatever decision you ought to take based on a particular decision stays.
Kamal, you know what? Because at some point, there must be a time frame at some point. Yes. Because judicial process is going to going Court of Appeal, even to get the Supreme Court to want to take a decision.
The answer to Yini, ono oye NDC communications team member no san a lawyer legal practitioner na wo be no am wo say ono de ni susuye mu no ohun ni say the clerk of parliament o me say any parliamentary procedure o say ekwan na pepepe ana o fa so say e wo so declare the seat no vacant giving say ruling bia foforo bia mi send the seal of execution and I say seal of execution say I was say seat ya already declare no vacant no and I was say clerk na twentwen so no sa ruling from high court no enya maya ne de na say the initial ruling is still binding. In fact case we ne de papa na in fact who follow so we fi ne ma bebre de free and that was the issue on style of execution. In fact say utie ya me say we fi ne ma bebre if you are on your way becoming a lawyer and Island TV Plus is the place to subscribe. You remember all the gist, all the happenings as far as the Pandai seat, concerned.